Lasting Power of Attorney by Rachelle Moore. So I'll just give you a brief bio of Rachelle. Rachelle Moore is a solicitor in the estate planning and wealth management team of her practice area. Rachelle studied law at the University of London before going on to complete her legal practice at the College of Law in Guildford. Rachelle qualified as a solicitor in 2016 and specializing in private client law. She has experience in working across a range of private client matters, including administrating both taxable and non-taxable estates, creating and registering lasting powers of attorney and drafting wills. She is also proficient in dealing with the transfer of assets as part of the estate administration process. Rachelle strives to deliver an excellent client service while adopting a sensitive and professional approach. Over to you, Rachelle.
Thank you, and good afternoon all, and thank you for having me on this very good sort of session today, covering different areas, and I just think it's very relevant. So I'm just going to share my screen, bear with me. So hopefully you can all see my screen.
Yeah.
So thank you, Joan, for inviting me. So yes, my name is Rachelle Moore. I'm a solicitor and I deal with private client law, which covers, as Joan mentioned, various aspects of law that we might need to deal with. Private client includes drafting and creating lasting powers of attorney, drafting wills, which obviously come into effect as you pass away, and then dealing with probate administration when somebody has passed away and carrying out the effects of their will. But today I'm going to focus on lasting powers of attorney and what these documents are and how they can be useful if they are ever needed. So the first slide, I won't take too long. I've got a short set of slides, and then of course we can go into some questions and answers. But the first slide says and asks, what is a lasting power of attorney? And these are documents. A lasting power of attorney is a legal document, and I might abbreviate it to LPA. So that is lasting power of attorney. It's a legal document that lets you, the person who's called the donor, to appoint one or more people to act on your behalf. Now, the people that you appoint, they're known as attorneys, and you are effectively appointing that person, that attorney, to help you to make important decisions on your behalf, as if that person was you. So as you can imagine, this document is very powerful because it is as if this person is you and carrying out your wishes. There are two types of LPAs that you can create. One is called health and welfare, and the other one, property and financial affairs. And they do what they sound like. Health and welfare deals with one side and property and financial affairs the other. And I will now go in and explain a bit further about the difference between the two different types of LPAs that you can have. So what is the difference? So health and welfare, lasting power of attorney, this gives your attorney, the person that you appoint, the power to make decisions about things to do with your health, including medical care, whether you need to move into a care home, life-sustaining treatment, if it is a situation arises where at end of life, whether to refuse or consent to life-sustaining treatment. And the important thing to note about this document, the health and welfare one, is that this LPA can only be used if and only if you were to lose mental capacity and that you couldn't make these decisions, that decision about your health and welfare for yourself. So it's a document that can be registered in advance, but it can only be used only if you lost mental capacity. And what I tend to do, and I think a lot of law firms tend to do, is we would keep the original of this document, and we would only ever release it to your attorney if they produced us evidence to confirm that you have lost mental capacity. So, for example, a letter from your GP that says, unfortunately, we believe this person can no longer make decisions on their behalf. And then we would release that document if the need arises for your attorneys to want to make decisions about your health and welfare. The second type of LPA is called property and financial affairs. And like it sounds, it deals with property and finances. And again, it gives your attorneys the power to make decisions on your behalf about money and property. So for example, managing a bank account, building society, and going in and paying bills. So your attorney can go in if you don't do online banking, for example, and you're not able to pop out to the bank. And I think quite a few banks are closing now. I went to my local one at, in Reading, and it was shut. And I was like, so I had to sort of find another way of paying in a check. And so your attorney could go on your behalf to your bank, pay a bill, take out money, and do the things that you would like them to do because you, for whatever reason, can't go. And as much as selling your house, I mean, there's sometimes when, you know, you are living in a big family home and you might want to now downsize to a smaller property, and your attorney, again, can act on your behalf and do that. I, in a previous firm, did a bit of conveyancing, and if an attorney came up to me with a lasting power of property and finance LPA, then I would act on their instructions. Once I got their ID and I was satisfied that they are who they are, that document said that they could act for the donor and would sign all the relevant paperwork in order to do what they were asking to do. And therefore, as you can imagine, it shows how powerful these documents are. The other difference between the health and welfare and the property and finance one is that the property and finance one can be used straight away as soon as it is registered. I mentioned earlier that the health and welfare one only comes into effect if you lost mental capacity, whereas the property and finance one, you can actually choose how you want it to be registered. You can choose for it to come into effect and to be used straight away once it's registered, or you could choose to say, I only want my attorney to be able to use this document if I lost mental capacity. I tend to explain to my clients that with the property and finance one, it doesn't make much sense to only let it be used when you lose, or if you were to lose mental capacity, because a lot of the time, the reason why people want to produce this document is that they might not be as mobile, for example, and they want to give their attorney, often their children, the ability to go and sort of do the sort of day-to-day activities that they just can't always do. So that is the main difference. One, health and welfare deals with your personal medical needs, whether you were to go into a care home, life-sustaining treatment, but can only be used if you lost mental capacity. And the property and financial affairs one deals with your money, deals with property, but can be used straight away as soon as it is registered, or you could caveat it to only be used if you lost mental capacity. So that is the difference between the two documents. So moving on to the next slide, who can make a lasting power of attorney and how do you make one? Well, of course, you've got to be over 18 and you have to have mental capacity. Now, I think this really ties in with what we've heard from our first speaker. You have to have the ability to make your own decisions, to know that you're making this document, because as I've explained, it's a very powerful document and it gives the attorney the power to act on your behalf. So you need to understand, and one of the things that I do is once I'm explaining to the clients the nature of these documents, I'm also sort of, whilst doing that, trying to make sure that they understand exactly, you know, what this document does, that they're happy that it's giving the attorney the power that it is giving. because you've got to choose. So as I said, you're the donor, and you have to choose who you want to be your attorney, how you want them to act. And 9 times out of 10, if I see a client, it's generally the parents saying, right, we're now at a stage where we want to make these documents. And when I'm asking who do you want to appoint, as I said, majority of the time, it is they're asking to appoint their children if they have children. If not, they're, it could be anybody. It doesn't have to be a children. It could be a cousin, friend, anyone who is trusted. And I think that's a point that, I would really stress. You have to feel that this person would act in your best interest on your behalf. And so you would appoint somebody to do that. And I would always recommend that you have at least more than one. You can appoint somebody solely, but always then have a replacement. So that means that the first person can act on their own. And if for whatever reason they couldn't continue to act, then the replacement steps in and acts on your behalf. Or you can appoint 2 people together, or 3 people, or 4 people together, and they can all pretty much act at the same time. And then if you're choosing that scenario, I would ask, are you asking them to act jointly or jointly and severally? Jointly, again, makes the document a little bit more restrictive, because it means if you had 4 attorneys, it would mean that all of them would need to be at the bank at the same time to kind of approve, a £50 transfer, for example. Whereas if you were to say that they can act jointly and severally, it means that they can individually go into the bank on your behalf and act for you. And again, I would explain the difference to the client and say, this is what it does, and it's up to you as the donor to decide how you'd want your attorneys to act. And so going on to creating the form, it's a form. It's a form that has to be completed, and you can actually decide to do this yourself. You can go onto the government website and download the forms, or you can pay for a solicitor to prepare the forms on your behalf. If you choose to prepare the forms yourself, you would need to choose an appropriate certificate provider, and that is somebody who is confirming, like I say, that you have the ability to make these documents, that you understand the nature of these documents, that you've effectively got mental capacity, and you're happy with what you're doing. Because, as I said, the power is so strong that you don't want to feel that someone has been coerced into creating these documents and then something is not, done correctly by the attorneys. And once the forms are filled in, we have to send them off to the Office of Public Guardian. I should just go back and say, if it was a solicitor, if I was dealing with the forms on your behalf, I would therefore be the certificate provider, because I've taken you through the forms, I've explained what these documents do, I've collated all the information that you've provided to me, and then there's a section where I would then be saying, I'm satisfied that you understand the nature of these documents, and that I believe that you have the mental capacity to make these documents. And once all those forms are completed and signed, I then send them off to the Office of Public Guardian, and that is the place. It's also abbreviated OPG, you might hear sometimes people say, but that stands for the Office of Public Guardian. And they register the document, and it becomes an official document, and they can be used straight away. As I said, health and welfare can only be used if you lost mental capacity, but the property and finance one can be used straight away once it's registered, if that's how you choose for that document to be used. But there's a waiting sort of backlog with the Office of Public Guardian. It can take up to 20 weeks. And once they've all been signed and dated and they're ready to go, it can take up to 20 weeks to be registered. And that is purely just due to their backlog. So it's not something that is instantaneous. And therefore, again, when you're thinking about, do I need these documents, it's something to be aware of. And we'll come on to just about the mental capacity is an issue, but also, the speed in which you might need such a document, it's not going to be a quick turnaround. I do believe if we were to call up the Office of Public Guardian to say, look, we've sent you some documents, we do need them urgently now, where are they in the pipeline, that, you know, you could try and get them expedited. But by and large, it is a bit of a wait to get these documents back. And I have had some clients be quite shocked, thinking, oh, it's going to take, you know, another 5 months to at least get these documents back. So that's something to just bear in mind, that it's not instantaneous. So again, it's about thinking ahead and planning, because if these documents are needed, they are very useful documents indeed. So onto the money. How much does it cost? Now, the Office of Public Guardian, they have their own charge to register these documents. So that's separate to any fee that a solicitor would charge. And at the present, it's £82 per document that the OPG, Office of Public Guardian, that they charge. And that is to register. So I suppose that is their time taken to double check the contents and that it is all done satisfactorily, because it's got to be all signed and dated correctly, otherwise they reject it. And if they do reject it, they used to be very kind and sort of say, look, there's been an error, please amend it and we'll process it. Now, I think probably with, you know, all the different expenses, they actually just reject it and say you need to complete it all again and pay the whole fee again. So again, you've got to be very, if you are choosing to do it yourself, make sure you take your time to follow the steps for it to be done correctly. Otherwise, you could end up having to be requested to do it again. It does mention there that you can qualify for a reduction or exemption of that fee, that £82 fee, depending on your status. I think if you're on certain levels of benefits, then they might reduce the cost. And more information on that is on the government website. And so if you were to do it yourself, then it would just be that £82 per document fee, but you'd have to find somebody. Earlier I talked about a certificate provider who would have to sign the form. So there is just a set list of people that the Office of Public Guardian are happy for them to sign the section, which is basically saying that you understand the document and that you have the capacity to make the document. If you were to ask a solicitor to prepare the forms for you, then in addition to that £82 fee per document, then of course the solicitor, we would charge our own fee, and that is the time taken to speak to you about the forms, to complete the forms, our time also assessing you to make sure that we're happy that you understand that the nature of these documents. And then and so that would be, you know, it is more expensive. I'm not going to say it's not, but then you would know that it is sort of completed, you know, correctly, and you know there wouldn't be any issue with it being rejected by the Office of Public Guardian for not being completed as it should be. So, should I make a lasting power of attorney? Very good question. And you know, I hear some people sort of say it's like an insurance document. You might not ever need it, and you know, especially on the health and welfare, you know, we would hope that it wouldn't come into effect because you haven't lost mental capacity. But the bottom line is, you know, we never know if that need would arise, and it is very important. It's an important document if that need does actually arise, for your attorneys to have that ability to act on your behalf. As I've explained, the health and welfare, they can make certain decisions for you if you lost mental capacity, and the property and finance one, they can use straight away if you were happy with that, and do day-to-day tasks like paying your bank bills, you know, calling up a utility provider. And you know, sometimes you try to call it and they're, are you the account holder? And you're like, no, well, I can't speak to you. Again, if that document was registered with them, they would speak to the attorney. So it does have its, you know, uses and advantages if it was needed. And it isn't something necessarily just for older people. It can be used for people of all ages. And again, I think it's about deciding whether it's right for you. And then if you are deciding that it's right for you, it is very important to remember that it can only be made if you've got mental capacity. So listening to, and it was very useful actually for me to listen to Dr. St. Joan about the stages and the things to look for, from the Alzheimer's dementia aspect, because it can be very borderline when we're sometimes seeing clients that are very close to that line of, do you have capacity? Do you understand the nature of this document? Even when I think like it is a very useful document for you to have, I can see that it's a useful document for you to have. Sometimes we have children bringing in their parents kind of because they know that actually we need this document now. But we're sometimes in a position where, are you able, does the donor really understand what these documents, and therefore have they got the ability to make them now? And so, because the alternate, if you are trying to make a lasting power of attorney when you no longer have capacity, then that document cannot be drawn up. And the alternate for the family members would be to make an application to the Court of Protection for a deputyship order. And this route is it's more expensive, it is very costly. There is no guarantee that that order will be created, because it has to be submitted to the Court of Protection, and they ask for a lot of information, again, to say, is this in the best interest of this person? And so I think, in summary, I would say lasting powers of attorney, they are powerful documents. They are very useful documents if there is a need for this documents to be used, but also to be very mindful that you have to A, have mental capacity to be able to make it, and B, you will be appointing attorneys. So you need to be very, as satisfied as you can be that the people that you are appointing are people that you trust and know that will act in your best interest. There are ramifications, of course, if people were to do things which raises an eyebrow, but sometimes that can be too late. And so you need to sort of think about who you would trust to give that power, that level of authority over your life, and then appoint them. But I think I'll stop there and hand over for questions and answers.
Thank you very much, Rachel, an excellent presentation. So I hope everyone's all knowledgeable about LPAs. But so now is the time for Q&As. I know there's some questions in the chat. Well, whilst everyone's preparing their Q&As, I'll just read out the first one. What age can someone appoint an LPA?
So you need to be 18. So once you're 18, you have the power. So if I was the donor, I was the person wanting to give Joan the power to act for me. Once I'm 18, I can give her that authority.
Okay, and the next question, do I need a will if I already have an LPA?
Good question. So that there are different documents. So LPAs, lasting powers of attorney, deal with what happens to you during your lifetime. As soon as you pass away, lasting powers of attorney, they no longer have any power and they effectively need to be cancelled. A will comes into effect only when you die. And so if you haven't made a will, your assets that you own as of the date of death will pass by the laws of intestacy. And that's not always the way that you would want your assets to pass. So by drawing up a will, you're ensuring that the assets that you own are left to the people that you want to leave them to. So, and I would also just say regarding LPAs, in your lifetime, I have had it where, unfortunately, sometimes someone has died and the attorneys still think that they can act under the lasting powers of attorney, and they've gone to the bank and started to draw up money with the good intention of paying, say, funeral bills, etc. And we have to sort of say, no, you can't use that document anymore. Stop it. Give it back to me so I can get it cancelled at the Office of Public Guardian, because now when you write a will, it's the executors who have now got controls, and so you might appoint your attorneys might be similar to who your executors are. And I think in one of that cases that I had, the attorney was similar to the executor. They were the same people, so they just thought, well, I'm still acting, but you kind of like, nope, you can't act under the lasting power of attorney anymore. You now need to sort of start following the rules under a will. So I hope that answers the question.
Okay, another question. What is the difference between a probator and an LPA?
A probator, I don't know if you're thinking about probate. Now, probate, grant of probate, now that is, again, what you get once you have a will, and if you need the grant of probate for certain assets, sometimes when someone dies, you don't actually need a grant of probate to call in all of the assets of the estate. Sometimes you do. If there's a house that you want to sell, you will need a grant of probate, for example. Or if there's a loss of money in the bank account, some banks will only release the money over a certain limit if they have a grant of probate. So that is what grant of probate is. It's to deal with assets after you've died. And LPA is to do with your attorney acting on your behalf once you're alive, either in the capacity as under the health and welfare, if you've lost mental capacity, or property and finance, dealing with your assets as you're alive, helping you effectively. LPAs, as the donor, you're asking your attorney to help you do things once you're alive. Once you've died, it's all about the will and whether you need a grant of probate.
Right, okay. Sorry? Right, and any other questions?
Yes, I've got one question, a couple of questions. In order to establish racial mental health capacity, what are the challenges in establishing that?
Yes, I mean, for me, initially, it's a case of when a client calls up asking for these documents, I will bring them in, we'll have a meeting. Since the pandemic, we've been doing a lot of things via Zoom as well, actually. But it's having a meeting with the client. And so for me, I'm having a conversation. I'm asking them what they believe the documents are, what they want them to do. And I think, once you've sort of spoken to somebody, for over a period of time and for some length, you start to understand, and even actually listening to the previous speakers' sort of information, you start to look out for things to see whether you think that they have the capacity. But I mean, I sometimes have clients who call me up and they sort of already say, look, I've stopped remembering things, I don't know this, and they're not sure whether they even have capacity. And at that point, I might have to say, can you provide me with a doctor's letter? And the doctor, if the doctor, because again, I'm not a medical professional, so if I've got any concerns, I would ask the client to provide me with a GP letter to say whether the doctor felt that they had capacity, and then I could proceed. But I think in my experience with speaking to clients, you get a good feel of whether they've got the capacity and that they understand. But if I'm ever concerned, then I would revert to a GP and ask for a medical opinion.
And a follow-on question: in a case where there's fluidity in the capacity, would there be easy to change the LPA in case there's a fluidity? For example, because you've got capacity, and the capacity waivers, you give a decision here, but that you want to change that decision at later stage when your capacity becomes more astute or more intact. It's fluid. How do you work that out?
So I think this is the question about if you're the donor and you've appointed to some attorneys, and then you want to change who those attorneys are, because if I'm the donor and I've appointed some attorneys, and then those attorneys continue to act for me. If I then start to waver in my capacity, these documents don't change, and those attorneys can continue to act for me. If I was the one, the donor, wanted to go, actually, I'm not sure if I want, you know, Joan or Richard as my attorneys anymore, then it's about cancelling those LPAs and creating fresh new ones. But of course, if we're at a stage now where capacity is questionable, you might not have the ability to make a new LPA and revoke the attorneys that you've appointed previously, if the capacity level is slightly wavering. And from my perspective, if I've got any concerns about whether somebody is able to make new sets of lasting powers of attorney, again, I would be asking for a doctor's letter to confirm their level of capacity.
Okay. Thanks very much for this answer.
Yeah. Sorry, go ahead.
I've got a question here. Probably quite humorous, but there might be something serious. If I make a good friend my attorney, and I verbally tell them I don't want to go into a nursing home if I get sick or get dementia or something, and I get dementia, can they put me in a nursing home and sell my home against the wish of my daughter who lives abroad, even though I told the good friend that's not what I want?
No, so I mean, it's a good question. I mean, the document, the health and welfare one, now that one would be to do with the health and welfare one that only comes into effect once you lost capacity. You know, you would hope that, you know, you've set out that wish, or you've told them verbally that that's what you wanted to do. The document itself gives that attorney the power to act on your behalf once you've lost mental capacity in your best interest. So in theory, if that friend thought, well, look, I know, you know, my friend said he didn't want to go into a care home, but he's now lost capacity, this document now comes into effect, and in his best interest, I think it is for him to go into a care home, then in essence, that document gives him that power to do so. If there was other people, and I think this is where the question comes in about, if other people around your circumstance kind of thinks, well, actually, this is, as you say, your daughter, this is not what I know my dad would have wanted, even though this is what this attorney has the authority to do, it comes to a question of, well, are they going to raise any alarms about that? Are they going to call anybody else? And I think, you know, you can't control completely what somebody does on your behalf when you're giving them that authority if they're acting in your best interest. But with that scenario that you've just posed, you know, you've said you wouldn't have wanted that. And so I would hope then that if that was to arise, that people around you would kind of say, let's look into this a bit more. Let's kind of ask a few more questions. Let's even in the worst case scenario, and I don't, you know, when attorneys are acting completely irresponsibly, this is where you would hope that people would ring up, you know, make an alarm about it, would ring up the Office of Public Guardian and say, I don't think this person is acting in the best interest, and then that would have to be investigated. But this is where I come back to, when it comes to appointing an attorney to act on your behalf, you really want to, you know, with the best will, sort of pick people who you believe will act in your best interest. And ultimately, we don't know what will happen, but we would hope that they would do that and follow your wishes as much as they can.
There are two more questions on the in the chat. I don't know if you've dealt with this one. I'll quickly read them. If we don't have an LPA or will in place, what happens to someone's assets acquired? And if someone's has assets and disposes of it before death, what can happen?
Okay, so with the first question, if you don't have an LPA, once you die, an LPA kind of, or if you did have an LPA, once you die, they are null and void anyway. So once you die, LPAs are no longer relevant. They do not, the attorneys no longer have power. The will comes into place. If you don't have a will, I think the question says, what happens to assets? So with the will, it sets out, when you write a will, you set out what you want to happen to your assets once you die. You appoint executors, trustees, and you say, whatever I have after any taxes, and sometimes there are a lot of taxes that have to be paid, but whatever I have left, I want it to go to A, B, and C. If you don't have a will in place, then it goes under the law of intestacy. And again, you can go onto the government website and have a quick look at what that means. If you don't have a will, the government have set out a kind of a tree of what happens. If you've got a spouse, it will automatically go to the spouse. If you've got spouse and children, there's a certain amount that will go to the spouse first and then to the children. If you've got no spouse or children, I think it then goes to parents who are surviving, if you've got a parent that survives you. And if you haven't got any parents, I think it then goes to siblings. There is this whole tree of how it goes if you don't have a will. And a lot of the times, if you kind of go and look at that, you might say, well, actually, no, I don't want it to go to that person if I didn't draw up a will. So again, drawing up a will, which sets out your wishes to what you would want to happen to your estate, your assets, as you pass, is a very good idea, because at least you then know you're in control of where your assets go.
Just wanted to
and I think there was the other question. What happens if someone has assets and disposes of it before their death? What can happen? Well, it's your assets. You know, live life. If you want to spend all your money, then you can. They're yours. And then once you pass away, it's whatever left. I know my mum says, well, you get what you get, and it might not be much because she's going to enjoy it.
I just wanted to mention that one quick point. Can you hear me?
Yes.
Yeah. There is something called that we as doctors look at is an advanced living will, and it is a document that a patient can complete, which sits in the medical records, and it determines what happens to that person in the event of them becoming mentally incapacitated or unable to make any decisions. And that advanced living will would actually overcome that situation that the other gentleman mentioned, whereby he's given decision to a friend, because it would determine whether that person gets CPR or not, whether they are just tube fed or not, whether they're just made comfortable. So there is that slight loophole.
Yes.
Okay. Right. Thank you very much. I think we've run out of time. We're closely running out of time. So thank you very much, Rachel, for an excellent presentation. Thank you very much. A round of applause.
Sorry. There was a quick question there that said, what safeguards are put in place if someone has a learning disability? Can they make these choices? That was quite interesting, I thought.
That's a very good question.
Yeah, so that comes down to the court of protection. So if somebody doesn't have the ability to make these documents just themselves, then the family members can say, well, look, this person has, I had a case where unfortunately the dad died, the beneficiary was a child, but they also had learning difficulties, so they wouldn't be able to sort of receive the assets themselves and deal with it. Therefore, the child's mother, as the closest sort of personal representative, had to apply for a deputyship order, and so the Court of Protection appointed people to act in the best interest of that person. So there are the Court of Protection deals with people who don't have capacity right now, or they've got disabilities and they can't necessarily make these decisions, and then they will appoint appropriate attorneys, effectively, they're called deputies, to act on their behalf in their best interest. And that's a whole different sort of process, but there is still that route that can be used in order to cover that situation.
Thank you, thank you, thank you, thank you, thank you. We have to move on swiftly to our next speaker, which is Dr. Stephen Lawrence, and I'll hand over to Richard.
Thank you, Sister Rachel, again, for that wonderful, wonderful presentation. I think that all of us here on this platform has been indeed inspired, and we've learned a lot on the topic.